So my name is Judy Chamberlain. I'm a family physician. I've lived and cared for families in Maine for over 30 years. I am going to speak today in opposition to all three bills, LD 760, 1193, and 1339. I trained at Eastern Maine Medical Center in Bangor. I practiced family medicine in Dexter for 16 years and then for 11 and a half years in Brunswick, and since then have been working with Medicaid on a national level. In my years of family medicine, I've delivered over 2,000 babies and also performed abortions when that was what my patients chose as an option. Honest and compassionate discussions with my patients and families were always a part of the decision-making process. In my written testimony, I did provide some information about the declining rate of abortion and of teen pregnancy in Maine and the safety of abortion, the fact that teens account for only 15.5% of abortions, and teens under 15 only 0.5%, or 1 in 200. But really today we're talking about two bills having to deal with informed consent and consent of minors that I want to mention. Maine's informed consent law that currently exists is very clear that before performing an abortion, I, as the attending physician, have to certify in writing that the woman gave her informed consent, written, freely, and without coercion. This consent includes my telling her the number of weeks of her current pregnancy, the risks associated with this pregnancy, and the abortion technique to be performed. The law also requires me to inform a woman of alternatives to abortion at her request. LD 760 amends that law to add requirements that alternatives to abortion be provided to the woman whether she asked for that information or not. In practice, I would offer to discuss a full range of options with a woman in my care, but LD 760 scripts that conversation with no room for medical judgment about what's appropriate. I can't imagine, for example, having to counsel a couple who sought abortion because their baby was severely deformed and would not survive outside the mother's womb about alternatives, including adoption, and also being required to go into detail, even scientifically accurate detail, about her fetus, as LD 760 would require. Similarly, discussing the liability of the father for child support with a rape or incest victim who's seeking an abortion could be cruel and traumatic for the victim. But LD 760 would mandate that conversation. As physicians, we want our patients to be informed and supportive, and we have both ethical and legal incentives under current law to ensure that they are fully informed and fully consent. There is no need to add to the current statute. LD 760 substitutes a scripted and politically motivated list for the very real expertise of practicing physicians and for the personal relationship between a physician and patient. LD 1339 requires parental consent for abortion with a judicial bypass. In my practice, I always encouraged minors and often helped them to talk to their parents about difficult issues. Judicial bypass is not a viable option for most minors. Going to court is both expensive and intimidating, and in my experience, it's very difficult in rural areas like Dexter to keep a court appearance confidential. Court proceedings can take a long time and will inevitably delay the date upon which a minor can receive a legal abortion, resulting in more abortions after 12 weeks. LD 1339 also establishes a new procedure whereby a sibling, grandparent, or step-parent could provide consent only if the minor signs a written statement indicting her parent for abuse. Imagine forcing an at-risk minor to choose to indict a parent in order to obtain a safe, legal abortion. Maine's current adult involvement law is working exactly as it should. Most teens are involving a parent, and some involve another adult family member. A small number involve a statutorily approved counselor. I recognize that even in the closest of families, talking about abortion or unintended pregnancy can be difficult. I'm comfortable as both a physician and the mother of a now 20-year-old daughter with the fact that Maine's current law on informed consent for minors requires adequate adult involvement and adequate information to the minor about alternatives. LD 1193 creates a separate legal status for the fetus as distinct from the mother. It establishes a legal definition of viability at 12 weeks, a gestational age at which no baby has ever been delivered and survived. While the language is drafted in such a way as to suggest that abortion providers would be exempt from a lawsuit, a closer look at the language reveals that lawsuits are not banned at all. It would force doctors to go to court to defend the legality of an abortion and the legality of the informed consent process. The women who seek abortions are adults, minors, mothers, students, Poor women, rich women, married women, single women, sometimes victims of incest or rape. They are women you see in your everyday lives and even in your families. They make thoughtful and carefully considered decisions every day, and with their physicians, they can and do make informed decisions about their body and about the outcomes of their pregnancies. Maine's current laws are working to protect Maine's families, and I will urge that all three of these bills come out of committee with an ought not to pass recommendation. Thank you.
Thank you, Dr. Chamberlain. And our final presenter is Leah Copeland, a nurse midwife who works with mothers in pregnancy decisions. Leah.
Good afternoon. My name is Leah Copeland. I'm a mother of two from Portland, Maine, and an assistant professor of nursing. I've worked in the field of women's health for 20 years as a counselor, a labor and delivery nurse, and a midwife. It is staggering to me as a practitioner, as well as an academic with a passion for evidence-based medicine, that we are still debating the same issues that we have been debating for decades. LD 760 places a wedge in the provider-patient relationship that is unnecessary and dangerous. As providers, we already uphold a commitment to provide accurate information to our patients, and we work with patients individually to provide them with the guidance and information they need when making any decision about their health. LD 760 is an unacceptable and unnecessary intrusion into private health care decisions. Having been with teens during abortions, I have watched the counseling that goes on, and I can tell you it works. As the data show, the majority of young women already discuss this decision with their parents. And from what I have witnessed firsthand, the ones who haven't are ones who have very legitimate concerns about the repercussions of sharing this information, including fears of violence or being forced out of their homes. I've worked with teens for close to 20 years and always encourage them to speak with their parents when making decisions about their reproductive health. But I also know that this is not a realistic option for many of our teens, and for their safety, we need to defeat LD 1339. Finally, I imagine that there's not a person in this room who does not feel that physically assaulting a pregnant woman is appalling. Again, I have seen firsthand the physical and emotional toll that such violence takes on pregnant women. However, the point of LD 1193 is not about preventing such crimes. It is about an attempt to threaten the precedents that allow access to safe legal abortions. Establishing personhood for a fetus at 12 weeks is not the way to go about reducing the very real issue of violence against women. Let's work on strengthening legislation to keep all women of our state safe, not chip away at the rights women already have. As a nurse and an educator, I implore you to reject LD 760 and LD 1339 and uphold the relationship and privacy practitioners and their patients deserve and women's rights to have abortions. And as a mother of a soon-to-be teenage girl, I implore you to reject LD 1339 so that I know that my daughter and her friends, should they ever need to make a decision to have an abortion, will not be faced with unnecessary tangles that can ultimately deprive them of their health and safety. Thank you.
Thank you.